Good morning, happy Friday, and welcome to today's webinar presentation, What Families Need to Know About Planning for a Loved One with Special Needs, presented by Elville and Associates Managing Principal and Lead Attorney, Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. Welcome to those that are new to our educational webinar series, and know we have plenty of new attendees, and also to those that are frequent attendees as well. As always, we encourage your general questions throughout the presentation, and please note them in the questions panel on your screen. And more case-specific questions and personal questions may be best discussed in a consultation with Steve at a later time. Your questions always add value and help others learn, so please present your questions at any time. You also received the presentation slides by email from me yesterday. To take notes if you wish, they're also available in the section marked handouts on your screen to download at this time. Welcome to our professionals on today's presentation as well. For CFPs, CPAs, and most others on today's webinar, you may receive 1.5 continuing education hours for attending. And per my requirements on my end, if applicable, please email me your ID number if I don't have it as soon as possible so I can submit your CE hours for approval first thing Monday morning. Everyone will also receive a post-webinar feedback email right after the presentation. And as always, we ask that you please take just a couple minutes to fill out this very brief and simple survey, but it provides us very valuable feedback as well. So we appreciate you taking the time to fill out that survey for us. Here at Elville Associates, we always want to be a resource to you and your family for your planning needs. So consider a consultation or a document review with Steve after today's presentation. Use today's education as a jumping off point to get your planning started. They're a great way to get your specific questions answered, have Steve understand your individual situation, and help create solutions and a path forward for you. So I'd like to offer Steve and the firm a brief introduction, and then we're gonna learn what brought you here today, and we're gonna jump right into the presentation. So Elville & Associates, founded in 2010 by Stephen Elville. We have several different practice areas that we focus on here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members in 5 locations, and Steve and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, client education, and superior legal technical knowledge. And we focus on education a lot here at Elville & Associates, as many of you know. And we do that in many ways. One is through our planning processes with our clients. 2 is through over 100 educational webinars and workshops in the communities that we serve each year. We have several in-person presentations coming up as well, which I'll tell you about at the end. And also by way of our accredited client care program, we're one of only 2 firms in Maryland to have an accredited client care program accredited by the Client Care Academy in Boston. We also focus and work with the ideals of client education, collaboration, and compassion in mind every day with every client here at Elville & Associates. Just a bit about Steve. His work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different membership organizations throughout the country, Steve works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. Steve is a very seasoned speaker, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for an 8th time in 2023 and his 7th consecutive year. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. And I've been privileged to be the executive director of since then. So if you'd like to learn how we work to make a musical difference in the lives of children each day, I would love to share our story with you. Feel free to reach out to me when we have just a little bit more time. But right now, we have an important topic to discuss, which is special needs planning and what families need to know about it. Briefly, we'd like to get to know our audience and what's brought you here today, so Steve can tailor the presentation just a bit. So we have a poll here we're going to launch, and that poll is to get to know our audience. Please tell us what has brought you to today's presentation. If I can get that launched properly, there we go. And your choices are: I need to set up planning for a loved one with special needs. 2, I have planning in place, but it needs to be revisited. 3, I'm a financial advisor here to learn to benefit my clients. And lastly, I'm an interested family member here to gather information. So welcome to one and all. Hope you have some good plans for the weekends. My kids lead the exciting life. I'm pretty boring, so I don't have that much going on. We'll give it another 10 seconds or so.
Don't forget your golf game, Jeff.
Golf game's getting there, Steve. It's getting there pretty well. Try to get out there pretty soon again. All right, so we got about 90% of the attendees having cast their choice. 40% say I need to set up planning for a loved one with special needs. 24% say I have planning in place, but it needs to be revisited, and that's not out of the ordinary. 24% say I'm a financial advisor here to learn to benefit my clients. That's always great to hear. And another 12% say I'm an interested family member here to gather information. So thanks for participating. Thanks for being here, Steve. I'm going to make you the presenter.
Thank you, Jeff. All right, thank you so much, Jeff. And as always, I thank my longtime friend and colleague, Jeff Stauffer, for being our moderator this morning. And welcome, everyone, as I get my slideshow started. It's a beautiful Friday morning where I am here in the Columbia Gateway community. And we are just blessed to be here with you this morning. And I am so blessed to lead Elville and Associates as their representative this morning to give you this discussion of special needs planning. But I'm even more blessed to be involved in the special needs planning community. So I've had that great privilege for many years. So thank you for being here. Thank you for your interest in this information and for spending time with me and Jeff this morning on a Friday morning when you have so many other things you could be doing. So this morning, we're going to do what we always do. We're going to learn, we're going to go through this process, but I want to give you a framework before we get started. I like to do that. And I want you to think of this truly as a mini masterclass, a mini workshop that really covers the vast majority of information out there about planning for a loved one with special needs. But if I had to describe this, how would I describe this kind of planning? Well, to frame it, I would say this really is about creating a world. This is creating a world for our loved one. And we don't know to what extent, from my end here this morning, we don't know to what extent your loved one or your client, if you're an advisor on this call, and thank you for being on this webinar this morning, we just don't know the extent of the disabilities. And the world of disability, the world of capacity versus incapacity is very fluid. So I want you to use this material to think in terms of building a world of support for a person, regardless of what their disabilities are or to whatever extent that disability may be. And this world is in addition to what we most of the time, not always, but most of the time think about as the world of public benefits or the world of support provided by government benefits. So not all beneficiaries are going to take advantage of government benefits, but in the world of special needs, many times that is the case. But we're going to just think about this as, again, building a framework, building a world of support other than the world of public benefits. So again, thank you for being here. We're going to get right into the learning. I want to give you a set of tools to walk away from here today and say, I have something substantive, something that I can wrap my mind around, my arms around, and I can go forward with this, whether it's to help my loved one with disabilities, whether it's to update a current plan or construct a new plan, or if you are an advisor, a financial advisor or CPA or insurance professional or other professional on this webinar, how I can recognize ways that I can be of value to my clients. So with that said, happy Friday to you and weekend ahead. We're going to go ahead and get started now. And as I always have to do, I have to say, well, this is not really legal advice. It can't be construed as such because we are not in an attorney-client relationship on this webinar. But what we are doing is talking at a very high level, again, to give you those framework tools that you can do something with for whatever your goal or purpose is. So we just talked about why plan. And again, being redundant as I tend to be, we are planning for someone's life and needs to enhance that life, to enhance the quality of that life to whatever extent possible, and to protect that person. And again, not to restrict their potential. And every person is different. Every family situation is different. But again, thinking in terms of creating that world of support, that world of protection, that world of upside potential, that world of protecting against the downside, whatever our goals may be. Some of the benefits of planning, and those of you who have seen this before, we're going to drill into it again. Providing financial security. My first question to many people on this webinar this morning is, do you have an advisory team? I was meeting this morning with a wonderful CPA who truly cares about people. That's the kind of person you want to have on your team. Who is your financial advisor? Do they understand the world that you're living in, taking care of your loved one with disabilities? This is the kind of team, the financial advisor, the insurance professional, the CPA, the estate planning or special needs planning attorney. This kind of world of support for yourself is what is needed so that you can provide a world of support for the loved one. Understanding public benefits. This is a very fundamental thing. Very few people truly understand it. It's a challenge. We want to work through that. Again, selecting a proper team. Now, this goes beyond just the advisory team. This goes to the issue of advocacy and family member support if you're fortunate enough to have that. Appropriate housing. We know that many of you, this is near and dear to your hearts. How will you be able to provide that housing? What kind of housing will be appropriate? Can our loved one with disabilities actually be independent and live on their own or not? We just talked about advocacy, caregiving needs, that's kind of related. Coordinating the entire extended family around the plan. Some of you have families that are really unified around your loved one with disabilities. And some of you have family members where siblings, let's say, are not so unified. And there are various nuances in the family. So we have to look at that on a case-by-case basis and coordinate this family type planning. Protecting the beneficiary from the fundamental things we don't want them to be exposed to. Creditors and predators and potential fraud. All of those things are addressed in good special needs planning. And for many of you, but not all of you, it's preserving assets for other beneficiaries. God forbid our loved one with disabilities were to pass away before us or pass away in the natural order of things. Where does the money go after their passing, if there's any funds left in a special needs trust, let's say? And certain trusts provide for payback provisions, which is not preferred unless we have to go that direction, while other trusts, let's say mainstream planning trusts, like the third-party trust that we're going to talk about today, do not have a payback requirement. So preserving assets could be one of the goals of the planning. So we talked about this just, already about two times. We want to have a successful plan that includes the right team of advisors. This could include, again, an insurance professional. It could include, and probably should include, an advocate, okay? But it always, in my opinion, should include flexibility. Are we living in a fast-changing, very fluid world? Are we living in a dangerous world? I think we all know the answer to that. We don't want to have a static plan. We want to have a plan that has a chance to be flexible. We want to have a plan that you've thought about flexibility in the planning. So having an advisory team, having advocates in place. Some of you have been caring for a loved one for your entire lives, and we're all getting older. So you may want to start interviewing and vetting advocates. You may want to think about this. I would argue that one of the greatest issues in special needs planning and in planning in general is trustee selection, which we have a separate workshop to talk about, but advocates. Who is going to advocate for my loved one with disabilities? This is one of the biggest issues in the country today. Trust protectors. Trust protectors, or what we might call trust advisors in Maryland, these are special fiduciaries that can provide flexibility to a plan. Trust protectors are not mandatory, but we highly recommend that you build in this kind of thinking, build in this kind of flexibility into a special needs plan. So let's just move through the material now. If you have a pad of paper, if you have a tablet, whatever it is that you've got in your hands, or if you don't have one, I strongly recommend that you go run to get one. And let's make some notes. Let's jot down very specific points that strike you, and let's make sure that you write down questions that you have. We will stop periodically throughout the presentation to answer your questions. Again, this is informal, even though I'm doing a lot of talking. Please feel free to interrupt Jeff. He's a top-notch professional. He will field your question. He'll interrupt me, and I will also intentionally stop at various points of the presentation. So one of the things we want to do is use our imagination. We want to envision the future. Now, this is very hard for you. How do I know that? Well, with thousands of special needs family clients that I've had over the years, I've been privileged to work with, I just know for a fact that you don't have a lot of time, most of you. And we want to give you that time when you're engaging in planning. We want to give you time to think. We know that's a big issue. Again, where will your loved one live? That's a big issue. Some of you already know this. Some of you want to provide real estate or a condo of some kind, a house, a residence for your loved one, but you don't know that you can leave that loved one a residence inside of a special needs trust, a supplemental needs trust. So there's an answer to some of your questions right there. You can leave a residence in a supplemental needs trust for the benefit of your loved one, and absolutely you can do that. But where will your loved one live? What kind of care is required? Will a guardian or conservator be necessary? Now we have what I would call a continuum of capacity or incapacity. Should our loved one sign powers of attorney or advanced medical directives to avoid guardianship? Or is our loved one with disabilities on this side of the equation where they truly are vulnerable and they need a guardianship, and that's the appropriate thing to do? Or are they in the middle somewhere where they should have a supported decision-making agreement, which is now Maryland law as of the October timeframe of 2022? Or lastly, should they have a guardianship but still have a supported decision-making agreement under guardianship? So these are the incapacity planning type of issues for our loved one with disabilities, not for ourselves. Who else will be involved? We talked about the extended family or others. What kind of lifestyle? How many future challenges do we have, financially or otherwise? This goes back to the issue of, are you using your advisory team? Are you talking through these issues? And we're going to talk about financial projections here in just a few minutes. Building layers of protection, building layers of flexibility. These are the things that really can only be crafted or structured through a process of counseling, taking the time to think. This is not a wham bam kind of situation. This is a methodical process, and to understand that process is part of really allowing yourself this opportunity, so to speak, to do the proper planning. So proper planning really is just a process And in that process, we want you to know what your purpose is. And many of you know what your purpose is because your life every day revolves around your loved one with disabilities. But if you really don't understand your true purpose in this kind of planning, we will help you think through that and actually maybe have a few epiphanies about what your purpose really is. Now, part of this process of thinking and part of this process of design and kind of taking all of this and funneling it into something that makes sense, one of those major tools is creating a memorandum. So in routine estate planning, we encourage clients to develop something called a letter of wishes. Now, a letter of wishes is something that gives the trustee guidance. And we encourage you to have a letter of wishes as well. But oftentimes in special needs planning, we go one step beyond a letter of wishes and we say, why don't we call that a memorandum? This is not only just your wishes and desires, but it's a memorandum that talks about your actual loved one with disabilities. What are their preferences? Who are the family members involved? What are their eccentricities? What are their issues that we are dealing with on a daily basis? What are their strengths and weaknesses? Who are their physicians? What are their medications? I've had families that had a more catastrophic type of situation for their loved one, where they create an entire manual for the care of their loved one. So this memorandum or slash letter of wishes can be as much or as little as you would like it to be. What I want you to envision as you imagine the future, I want you to think about years from now, after your passing, you're no longer here, and you've thought through who your trustees are going to be. And most of those trustees understand your loved one. They know them. They are familiar with their needs, at least, because you've made sure of that. But I want you to imagine a situation where your loved one has a trustee in the future, a trustee that we cannot anticipate right now. We could not imagine or envision who that might be, but this is an unknown potential trustee. This memorandum of intent will give that trustee, at a glance, a snapshot of your loved one and what their life is all about, what their needs are all about, what their background is about. That's what I want you to think about. Is this hard work? Yes, this is very hard work, but possibly this is the most important thing in special needs planning. I want you to envision millions of trusts. Some of them are special needs trusts, some of them are not. Most of these trusts, vast majority of them, I would estimate well over 90%, have no letter of wishes. They have no memorandum of intent. So here's a huge opportunity for you. This opportunity is to make your trust for your loved one special, to make it special in a way that it is actually customized and personalized to the needs of your loved one. Now, taking a step back, as we continue to think about what the steps are really to go forward, we need to be thinking about future expenses. Many of you are doing the very best you can. You are saving money. You are sacrificing your own, let's say, needs at many times to provide for your loved one with disabilities. But even with all that you're doing, my experience has been that most families with a loved one with special needs do not have a financial advisor, or if they do have one, they have not really committed 100% in that area because many of you feel, as I have experienced, that the financial advisor who is involved may not truly understand your situation. Now, my argument would be, I don't believe a good financial advisor has to necessarily understand your personal struggle and daily work to take care of your loved one. But many of you prefer to work with financial advisors who do have a child with disabilities or understand what it's like to have a family member with disabilities. So I will have to leave that up to you, but I will just tell you that the use of resources of financial advisors, in my opinion, is very important, to use their resources available. The larger financial firms and even smaller ones have access to tremendous resources. And these resources can help you project into the future what the resources that are going to be available are for your loved one. none of us really know how much we're going to have when we pass away. So I'm going to encourage you to have a financial advisor and a team of advisors, and I'm going to encourage you to use their resources. These are old-fashioned resources. You can find these types of things on the internet, but I'm going to, again, strongly encourage you to utilize the resources that are available to you through the many financial advisor and other advisors that are available. Jeff, I'm going to stop just for a second to take a sip of water and see if anyone has a preliminary question.
Thanks, Steve. Nothing as of yet.
Thank you very much. So we're going to continue to plow forward through this material. Stop us at any time. Make important notes to yourself. Jeff will be providing this presentation to you if he hasn't already done so. So we've talked about a lot of things as we set the stage to start looking at special needs trusts and other things that you need to know. But planning for incapacity, we talked about this a little bit. And I want you to think about, again, a timeline, or a continuum, I should say, not a timeline, but a line, a straight line, horizontal, from left to right and right to left. And as you think through this, if you have a piece of paper, I want you to put on the left side of that line financial powers of attorney and advanced medical directives. Financial powers of attorney and advanced medical directives. On the right side of that line, the far right, I want you to put guardianship. Guardianship of the person, guardianship of the property. And in the middle, I want you to write supported decision making, or SDM. Now, if you've done that on that horizontal line, over here where it says financial powers of attorney and advanced directives, I want you to think or write down, this is the retention of rights. The person is retaining their rights. And what are they basically saying? Well, that person is basically saying, I can make my own decisions. And if I can't make my own decisions, my agent will. So that person is retaining their rights. Now, all the way over here on the right-hand side of the continuum, under guardianship, I want you to think and write down loss of rights. This person is vulnerable, is under a guardianship, and they cannot make their own decisions. They have been determined legally incapacitated, and this person has a loss of rights, they're vulnerable, and they need protection. Now, in the middle, I want you to think about this new concept called supported decision making. Supported decision making. And in the middle there, I want you to think or write down, I will make my own decisions. This is the person with disabilities. I will make my own decisions to whatever extent possible, provided that I have the support to do so. I will make my own decisions to whatever extent possible, providing that I have the support to do so. Now, what I want you to do after this webinar today is I want you to work with this continuum as you think about your loved one, and this will help you. This is a tool that I've developed to think about, or how to explain to clients, the concept of supported decision making and how it relates going back and forth across this continuum. The last thing I want you to write down is something you heard me mention earlier. Over here on the right-hand side of the page where it says guardianship and loss of rights, I want you to write supported decision maker, because Maryland allows someone that's under a guardianship to have a supported decision maker if the guardians basically agree. So that's a whole subject into itself, or unto itself. We have another webinar on supported decision making, but I want you to understand that continuum. And I think that's a good way to think about how will we approach incapacity planning for our loved one with disabilities. All right, let's talk about public benefits now. We are absolutely talking about a lot of things this morning, and I'm going through the material methodically because we want to get through and make sure we end on time, but that we also have plenty of time for questions. Let's talk about understanding public benefits. Now, I'm a very big proponent of using a whiteboard, using PowerPoint slides, but basically I love to get up on a whiteboard and draw things. And if we were meeting together, I would draw these boxes or these columns. And what I want you to think about here is this. On the left-hand side, we have SSI, Supplemental Security Income. Many of you who are on this webinar today, your loved one already receives SSI. And as a result, they receive Medicaid. In Maryland, we call this medical assistance. Now, what do we want to really say here about SSI? Well, SSI is the quintessential definition of disability because the person who is eligible for SSI is a person who not only qualifies medically, but they also qualify financially. So SSI and Medicaid is means tested. And many of you are all too familiar with the $2,000 asset limit. So here we have a means tested program. Now on the right-hand side, we have other public benefits. And here I'm not going to spend too much time, but I'm simply going to say that HUD housing, HUD benefits, these types of benefits in the right-hand column are very sensitive to how assets are distributed from a special needs trust. We don't have time to go into that today, but the HUD rules are difficult to deal with if your loved one is living in HUD housing. We are going to have to continue to work through those issues. And my understanding is that this year HUD is changing its rules, and lawyers like me have to make sure we're going to be up to date on those new rules. But where I want to focus here, other than SSI, is right here in the middle. And in the middle, what we see is someone who could be on public benefits is also someone who could receive SSDI, Social Security Disability payments, either on their own work record or on their parents' work record. Now, in many cases in special needs planning, this is the parents' work record. But the point to do here, or to go over here, is that the person who's on SSI, and I know that some of you on this webinar today do not know what I'm getting ready to tell you, and you will be happy to hear this if you don't already know it, that your loved one on SSI someday will transition. They will transition to SSDI. They will transition at your retirement. And what will happen is they will stop receiving, generally, they'll stop receiving SSI and begin to receive an amount equal to 50% of your Social Security payment. Now that means that generally they will get a bigger benefit, and they will automatically qualify for, in a certain period of months, they will qualify for Medicare. They're on Social Security Disability and they will get Medicare. But notice that many beneficiaries of SSDI here will also be entitled to Medicaid benefits. So the person who is in this middle category or transitions to this middle category, they may still be on means tested benefits, even though SSDI is not means tested. So they may still be on means tested waiver benefits or other benefits. So this is a very, very common situation where someone is either on SSI or they have transitioned to SSDI as a disabled adult child. At your death, this disabled adult child will receive an amount equal to 75% of your benefit. So this is good news to many of you who have never heard of this, and it's something to wrap your minds around as a wonderful thing. Now, is it possible for someone to be on SSDI and they are not in a waiver program or they're not receiving any kind of public benefits? And the answer is yes. They could receive SSDI on their own work record. And remember that if that's the case, they are not necessarily they're not going to be a disabled adult child. And it also means that they may not be on public benefits, but they could have unlimited assets. So you see, SSDI in and of itself is not means tested, but SSI is. But even though SSI is means tested, when someone's transitioning and they were disabled prior to age 22, as we're going to see on a following slide, they are a disabled adult child who receives SSDI based on their parents' work record, and they very well may be still entitled to means tested benefits. And where I'm going with all this is anyone who is entitled to means-tested benefits or on means-tested benefits in either of these first two categories, that person still needs to be protected by a supplemental needs trust. Now, SSI has tests. We're not going to spend a lot of time on that this morning. This is for your benefit and reading. Disability definition, we're not going to spend too much time on that, but that's an important thing to know about. The resource tests are here. Notice that a residence is not going to be counted. So someone who is on SSI could own a vehicle, could own a residence in their own name. It doesn't mean that they should, but remember that these are things of value that a person, even if they're on means-tested benefits, can still be owning. Now, many times a beneficiary that has disabilities will not own any of these resources, and those things would be owned by a trust, for example. So our SSI benefit in 2023 is $914. We're just trying to get your mind around this a little bit. There are concepts of unearned and earned income. I want you to take an interest in this because what you want to do here is learn enough about public benefits that you yourself never inadvertently cause the ineligibility of your loved ones by not understanding these concepts or to have them knocked off of SSI. So where do you get this knowledge? Well, you can use this basic set of tools that I'm giving you this morning, but you can also read. So I'm going to give you a book reference, and there are many books on special needs planning. The one I would recommend that I have kind of come to believe is kind of the quintessential guide is a book called How to Administer, now don't get hung up on the title, How to Administer the California Special Needs Trust. Now, the author of this book is from California, and there are many references to Medi-Cal, which is their form of medical assistance out there in California. But Kevin Urbash, U-R-B-A-T-S-C-H, Kevin Urbash, U-R-B-A-T-S-C-H. He's a wonderful man who I have very much looked to as a mentor at times in my career, who is the past chair of the Academy of Special Needs Planners across the country. This book, I think, is the best and easiest book to read on this subject, and he goes into great detail on these particular concepts. Don't be intimidated by the book, which you can buy on Amazon. It's got large letters. It looks very thick, but it's easy to read. How to Administer the California Special Needs Trust. In that book, you're going to see these concepts of in-kind support and maintenance and deemed income. We want not only you to understand these concepts, but we want your trustees to understand the concept. So that's something we're going to talk about a little bit further. Here's the SSDI eligibility test. We know this is a very broad subject. For those of you who have Social Security questions, Elville and Associates has partnered with a few Social Security firms in our state who actually specialize in Social Security. So just know that these resources are available to you. Here's a slide about the disabled adult child benefit if a child was disabled prior to age 22. So these are case-by-case, fact-specific situations. Medicaid and Medicare, these concepts are very broad. Again, as we try to make the most of our time here today, we're just going to gloss over these for today, knowing that you're going to have this material to reference in the future. We talked about Section 8 housing. One of the biggest concerns if we have a loved one living in Section 8 housing is that any distribution, and this is not fair in one way, we'll have to see what the new rules say, the new HUD rules, any distribution from a supplemental or special needs trust will potentially cause the rent of a disabled person to increase because HUD will attribute any kind of a distribution as income to the person. So we have to be very concerned about this. And ABLE, Achieving a Better Life Experience account, can be a way to get around this rule to fund an ABLE account for those who are eligible. And in that way, make distributions from the ABLE account to the loved one. And in that way, going from point A to point B to point C through an ABLE account, we can get past or get around some of these HUD limitations. We've talked about housing. We know, again, this is a very big issue. Some of you know your loved one will not be able to live independently. Some of you know they will have to have supported or group housing. Some of you are planning for other than that, and that's wonderful. And some of you will plan that your trustee will make that decision. So just know this is a counseling issue, and we know it's very, very important. Again, a special needs trust can own real estate, and it can own housing for your loved one with disabilities. All
Steve?
right, we're about to get part 3 of the presentation. I think, Jeff, we may have a question.
We do, thanks. And let me go ahead and grab that. So we've got 2 questions. First is regarding a letter of wishes from Jeanette. Hi, Jeanette. It's good to speak to you again. First question is, where would the letter of wishes or memorandum be stored? This document will be regularly updated over the life of the special needs individual. Do the trustees, attorney, and other persons in the support team need to be informed of each change?
Thank you for that wonderful question. And hello. I'm going to say that it would be stored in a word processing program somewhere, so it could be easily updated. So it does not have to be handwritten every time that it's updated. So that's kind of a thing I would do. It should be attached, in my opinion, to the back of a will or to the back of a revocable trust if the special needs trust is embedded in those documents, or if the special needs trust stands on its own, it should be attached to the back of that trust. So I think that's where it's stored, so to speak, as it continues to be updated over the years. I also think that there's an argument that the financial advisory team should have a copy. I think this is a privacy issue that most families with a loved one with disabilities would say the exposure of the personal information, you know, it's a good trade-off. We're exposing a lot of things to a lot of people. So I can't see any downside of the advisory team having a copy of that memorandum or letter of wishes, other than just the understanding that we're exposing a lot of personal information, which the trade-off is obviously the benefit to the loved one. Thank you for that great question.
And another 2 questions that are both related to SSDI. Maybe I'll pose them at the same time here. My husband and I are both retired and receive Social Security. Which of us counts for determining SSDI amounts? And then the next question is, will the SSDI distribution decrease the workers' benefits?
Wonderful questions. Thank you for being here today. It's going to be the larger of the 2 benefits, and it will not decrease your benefit. Though you as the recipient, it's only going to be an amount equal to 50% or at your death, 75% of the benefit.
Okay. All right, that's all for right now. Thank you so much.
Thank you for those questions. It helps our presentation. Okay, now we're on time, Jeff. We're going to keep going. Let's talk about special needs trust, which is why many of you are on this webinar today. So I want you to think about 2 major types of trusts. 2 major types of trusts which came about largely through a very large omnibus bill of 1993. So a long time ago. The third-party trust. A trust that is created by a third party, a trust created by you, let's say, for your loved one with disabilities, or created by a family member. I know some of you are supporting family members. A trust created by anyone other than the beneficiary. That trust is going to be the bread and butter. That trust is the foundational special needs trust, which, getting very technical with you today, I'm going to call this a supplemental needs trust. That third-party trust is what we are talking about today, mostly. This is a document that is created as part of an estate plan, and at your passing, if you are the loved one who is providing support to the one with disabilities, at your passing, whatever goes from this trust, and I'm going to call that point A. Let me rephrase what I'm saying, I apologize. the trust that you've created for the loved one with disabilities, and you are the third party, at your death, whatever you leave by way of your will, whatever you leave by way of your revocable trust, which remember is nothing more than a substitute for a will, or whatever you leave to your loved one in this third party trust that is a life insurance policy, or a transferable on death account, or an IRA, whatever you leave to that person, if it goes from you, point A, straight into the trust, I'm going to use my hands to create this bubble, this circle, that third party trust, that is going to be something that protects the beneficiary, protects them from losing their benefits if they have means tested benefits. It's going to protect them from fraud, the claims of creditors, and so forth. So that third party trust is what we're mainly talking about today. Now, upon death, as you go left to right across this chart, you'll see that it can go to the further beneficiaries that you designate. And recently, IRS made this more liberalized, which we'll talk about a little bit later, where you can freely name charities, even if you're leaving a large amount of IRA money to a third-party trust, the third-party supplemental needs trust. That's a mouthful, but that's what we're talking about. Even if you leave a lot of IRA benefits, retirement plan benefits, meaning pre-tax retirement plan benefits into that trust, you can provide for a charity if you're so inclined, and IRS is now allowing that. Now, that's the third party trust. I want you now to look at the second column and the third column here, and these are what we call first party trusts. So you see this is a little bit technical, but you're going to get it very quickly. The third party trust, someone other than the beneficiary is leaving money for the benefit of that beneficiary. Here, the first party trust, the beneficiary has received money themselves. They have received money in their own name themselves. This could be from an inheritance. It could be from a car accident. It could be from a birth injury. And many of you on this webinar know exactly what I'm talking about. So here we have two types. One is a pooled trust. This is a nonprofit organization that has been established, and it has a pool of money that is for many different beneficiaries. And this is going to be used in certain circumstances. And then we have the D4A trust. Now, for those of you who are more technical and you're wondering where these references come from, the D4A and D4C trusts, they come from the United States Code. And if you were in my field working with this every day, you would know that the reference to this is 42 USC, 42 United States Code, 1396, section 1396, D4A or D4C. These are the references for those of you who are wondering what I'm talking about there. So these are references in the federal law, but they're also references in the Code of Maryland Regulations, COMAR, for Maryland law. So these trusts can be established by certain individuals, parents, grandparents, guardians, or a court. But now even a beneficiary, a high functioning person with capacity, a person who has disabilities but has mental capacity, they can establish their own first party trust. Now, these trusts have paybacks to the state of Maryland or any other state where someone might be living. Yesterday, I met with a wonderful client who has a large property in another state. So someday they may move to that state. So the first party trust that they have in Maryland, that would be a payback to Maryland. If the beneficiary moves to another state at that beneficiary's death, there would be potentially a payback to the other state's Medicaid system in that state. So the third party trust is mainly what we're talking about today as part of routine estate planning, no payback to any state, very flexible. And the first party trust is the kind of trust where there is a payback. Sometimes it is inevitable to use a first party trust. For example, if a beneficiary receives money in their own name, we have to get that money out of that person's name. And sometimes it's just unavoidable. Sometimes there's a car accident or a birth injury and that there's no other choice except to have the money come into a first party trust. And of course, Congress several years ago allowed military veterans to leave their retirements into a first-party trust, and that is the vehicle that has to be used. It's a wonderful thing that veterans can leave their military pensions into a trust for a beneficiary, but it cannot be left into the third-party trust. It must be a first-party trust. So looking at this slide number 32 here, a third-party trust is the best method of providing an inheritance for a loved one with disabilities, generally speaking. And it's called a third-party trust because it's the assets of someone else that's coming from that person to this vehicle, this third-party trust for the benefit of the disabled person. Now, I'm going to take just a minute or two to talk to you about this particular slide. For several years, I really didn't see much of this in my practice, although I've seen many different types of trusts that were improperly drafted and they have problems, let's say, which is why all special needs trusts, all trusts in general, all wills need to be reviewed. But these are other arrangements. So let's look at this. I have seen this recently. I'd say in the last year and a half, I've seen 5 to 7 different cases where someone is actually thinking about doing this. So we don't want to leave an outright inheritance to a loved one with disabilities. I know that sounds ridiculous to many of you, but there are people out there that are still considering these types of things. And it's just not a good idea. It will cause a loss of benefits, and it will also cause money to have to be moved from the person with means tested benefits into what kind of trust? A first party trust. And that first party trust has a payback to the state of Maryland if there is any money left in that trust. So that's just not a good idea. The second bullet point here is that many people inadvertently are advised improperly, and they end up leaving money into a trust, and that trust does not qualify really as a special or supplemental needs trust. So they leave this money or property into what I would call a support trust. So I want you to think in terms of 2 categories of trust, not just the third-party trust and the first-party trust, but kind of a broader category of trust. There is a discretionary trust. That's the language I want you to think about. That is the special or supplemental needs trust. That is the special needs trust we're talking about today, discretionary trust. And then there are support trusts. These support trusts are for the benefit of, let's say, neurotypical or healthy individuals. Non-disabled individuals have a support trust. So if we left our loved one with disabilities a support trust, we would disqualify them from public benefits. So many times I will see improperly drafted trusts, or someone thinks they're leaving assets to a special needs trust that is a discretionary trust, a very broad category, but they're actually leaving assets to a support trust, which is incorrect. Now, recently I've seen a couple of cases where a family member says, well, we're just going to disinherit our loved one altogether and leave money to another family member. And that family member will provide for the beneficiary. Well, that's not a good idea for various reasons. Let's look at why. Well, that sibling, it's usually a sibling, could be subject to creditors. So you left money to a sibling to take care of the disabled sibling. Now they've lost the money to a creditor. They lost the money to a divorcing spouse. This is a hazard that could be something that happens, God forbid. The person who was left the money, the sibling, could die. And if they did not have their own estate planning in order, that money could flow to a person who certainly will not use the money for the benefit of the disabled person, or the beneficiary of that money could decide that they just don't feel it's suitable for them to take care of their loved one. They could have a change of mind, change of heart. So these arrangements are not recommended, and these are truly mistakes. So good special needs planning is not engaging in these kinds of activities. So again, to be redundant, a third-party trust is created where the beneficiary did not create their own trust. It's not a first-party trust. The trust does not hold any of the beneficiary's own money. It has to be third-party money. And the beneficiary is not a trustee, of course. There's no payback to the state of Maryland or any other state It can be revocable. These trusts can be drafted as irrevocable trusts, or for convenience and probably a lot of common sense in most cases, it can just be a revocable trust where it has no tax reporting during the lifetime of the creator, the grantor. And we want to draft flexibility into this kind of nice trust that is not really scrutinized by any government agency, and there is no payback. Trustee selection. I strongly recommend, if you're interested in this topic, we spend quite a bit of energy and time putting on a workshop on at least a quarterly basis, I think, Jeff, choosing the trustee or trustee selection. Nothing could be more important today. So family members versus professionals is one of the ongoing discussions. And I think in a traditional sense, many people think of a family member being the trustee. But a more modern view doesn't mean it's the right view, but a more modern or contemporary view is perhaps the trustee should not be a family member, but the family member should be an advocate, not necessarily the trustee. So this is going to be a family specific situation, case specific, fact specific situation. Some family members are going to do a great job. Others are not. And I know many of you are very worried about this. This is part of the time to think, time to consider, time to really take our a very slow approach in really examining all the options that are available and doing all of our due diligence. Now, let's say that we have a family member who's willing and you have the confidence in that person. Well, we want to make sure that your fiduciary, this trustee that you are appointing, we want to make sure that person is educated and understands all of their duties. Now, I'm doing an awful lot of talking, but I'm going to give you something here that may shock you. How many of you would believe me if I said that the average trustee has never read the trust? Well, it's true. Or the average trustee has maybe perused the trust once, but really doesn't spend a lot of time understanding it. And remember, the trustee has the duty to follow the guidelines of the trust and to act in the best interest of the beneficiary. All of these things that we have to discuss about this trustee selection process and building in flexibility and protections. So this is a big topic, and I want you to know that resources are available out there to think through this. Now, as we think through trustees, we want to think through the issue of trust protectors. We talked about that. Remember, the trust protector, it takes a little bit of time to get your mind around this. Maryland has only authorized the use of trust advisors / protectors since 2014. Elville and Associates has been utilizing the benefits of a trust protector for many years, but it's largely an unknown concept. It is not for everybody. It's optional, but it basically involves giving a trust protector, a special fiduciary, the power to direct the trustee. This is a lot that I'm throwing at you here. The power to direct the trustee to do certain things. So the trustee has fiduciary responsibility to follow the terms of the trust and to make distributions for the benefit of the beneficiary and to advocate for the beneficiary and to do all kinds of things. But the trust protector's powers are usually very specific. The power to remove and replace trustees, that may be shocking to you. The power to review accountings, in my opinion, in special needs planning, because our special needs loved one cannot review the accounting themselves, generally speaking. To be able to make modifications or amendments, administrative or tax changes to the trust. The trust protector is the special fiduciary who is authorized to do that. Now, it will take a while for some of you to really understand this and get your mind around it, but what is the end result of all of these powers? Well, what you're doing is you're putting in motion a document, a trust, a vehicle, but that vehicle is not static. That vehicle has flexibility down the road. Generally speaking, this is a very good idea. Counseling will help you get more comfortable with this notion. The Trust Advisory Committee is one of those provisions in a supplemental needs trust that can give you peace of mind. It can say, well, my trustee may, if they need assistance, if they need guidance, they can form a committee of people to give that critical guidance. Now, remember, a trustee can always hire professionals. So this is not their inability to do that. This is just the option, or reminding them that they have this ability to get this kind of advice if they need it. Sometimes the Trust Advisory Committee will be mandatory, not just discretionary, because maybe we have a loved one who has very significant, very serious issues, and this Trust Advisory Committee might have to be part of the fabric of the special needs plan. This diagram is not meant to be all-inclusive, but this is an idea of the contemporary nature of a modern special needs trust. So notice that we have this trust. I'm kind of showing that as a circle or a bubble. And we have these various features. Now, in the old days, many, many years ago, even before 1993, when the Omnibus Act happened, special needs trusts were more plain vanilla, should I say. They were not instructional, although I have seen very good ones from the old days as well. Today's trust, in my opinion, should be instructional. It should not just be legal, but it should be instructional. For example, it has provisions such as a memorandum of intent. What do I mean when I say make discretionary distributions for my loved one? What do I mean by my intentions for housing for my loved one? All of these things are designed to make the trust very personal to you. If I were to, right here in my office, stack up 1,000 trusts or wills, my opinion would be that most of them would look very similar because they have no memorandum of intent. They have no instructions beyond the trust itself. So we want to make it personal. We want to make it dynamic. My trustee should read this trust. They will see that they have an ability to hire an advocate. They have the ability to fund a Maryland ABLE account if the beneficiary is eligible. By the way, in 2025, ABLE will increase the age for eligibility for ABLE to 46 instead of 26. So those of you who don't know that, that's a good thing. Trust protectors, Trust Advisory Committee, special retirement plan provisions. Many of you may know that the Secure Act, that big act for taxes and retirement plans and retirement savings that was put into place by President Trump in 2020, that Secure Act has now been modified a few times by the regulations, but a special needs trust needs to be designed in such a way that it can receive an IRA, and that IRA or qualified plan is going to be treated specially, meaning the loved one with disabilities is exempt from the Secure Act. We're going to talk about that very briefly before the end. And that trust for that loved one is also exempt because the loved one with disabilities or a chronically ill person is exempt. They are called an eligible designated beneficiary. So a modern special needs trust is going to be an eligible designated beneficiary, not just the beneficiary themselves. Jeff looked very hard. Oh, Jeff, yes.
I'm so sorry.
Please
I
interrupt
thought now might be a good time to ask,
Yes.
answer a couple questions.
Yes.
Is now a good time?
Yes.
Okay, great. So first question is supplemental and discretionary trust the same thing?
Thank you for that. In my world of the legal side, we refer to first-party trust, the kind where the beneficiary received money themselves. We refer to that as a special needs trust. We refer to the third-party trust, the one that is the bread and butter of this notion of special needs planning. We refer to that as a supplemental needs trust. So first-party trust, special needs trust. Third-party trust is a supplemental needs trust. So all special needs or supplemental needs trusts in those categories are discretionary trusts. So hopefully that will make sense. The general needs trust, let's say you have a child or loved one who has their perfect health and you left them a trust for their health, education, maintenance, and support. That is a support trust. The discretionary trust is either the third-party trust or the first-party trust. The first-party trust is called a special needs trust. The third-party trust is called a supplemental needs trust. Thank you.
Okay. Next question, we are in the military and want to know if we have to use a first-person trust to give pension benefits to our loved one. Can we have a third-party trust for other assets and benefits, or do you just have one type of trust?
Thank you very much. That is a great question, and you've got it. You said it exactly. You can use the third-party trust for your family assets, your life insurance, your retirement benefits, other than a pension, and that would be appropriate. But your first-party trust would have to be developed and put into place for your loved one to receive your military pension. So that's exactly right.
Okay, thank you. Last question for now. What does ABLE mean?
Thank you. ABLE means achieving a better life experience. So this is part of what we call the IRS Code 5, Section 529 plan for a person with disabilities. So someone who is disabled prior to age 26, not 22, but 26, can have an ABLE account, and this ABLE account is a tax um, uh, preferred plan, or a tax advantage plan, I should say. And there are various ABLE accounts in various states. Maryland has its own ABLE account, and that is what I'm referring to. And many people see an ABLE account, achieving a better life experience account, as an advantageous thing for most special needs beneficiaries. And I do agree with that and think it is an advantageous thing. And it is not a substitute for a special needs trust or a supplemental needs trust, but it is an addition to or a benefit for those with disabilities.
Okay, thanks, Steve. Yes, we can send out our presentation we offered with Kelly Nelson of Maryland ABLE in my follow-up to everybody later on.
Thank you for those wonderful questions and helping our presentation. Now, in the interest of time, I'll move through so we can finish on time. Jeff looked high and low. I'm being a bit facetious here, but he really did. And he found these pictures, these photos of what I would call perfect trustees. These are the people we're really looking for out there. And as you think in terms of trustee selection, I really want you to use these, especially in special needs planning. I want you to use these concentric circles, in all seriousness, to really use as your benchmark. So we want a trustee that understands accounting. They don't have to be experts in accounting, but they understand that they do have a duty to keep accurate records, to keep the beneficiary informed. Yes, beneficiaries, even those with disabilities, have a right to information. This trustee understands that they have to comply with duties that are statutory about being a trustee. They have to understand basics of investments. They don't want to generally make investments themselves. They want to do what? Hire professionals. They want to understand taxes, yes, and their duties, but they want to hire professionals unless they are a professional themselves. They want to hire professionals to take care of these duties. But look at the top circle. This is where the special needs advocacy comes in. They want to understand the best interests, public benefits, promote independence and quality of life for this person with disabilities, and take that responsibility seriously. And I know many of you have family members and others who will. Those of you who don't have family members, we need to engage in a discussion of who non-family member trustees will be and what are the checks and balances so that you can have peace of mind, but also flexibility into the future if that particular trustee is not suitable or is not available anymore. So use this as a tool. Now, a special needs trust can pay for certain things. Remember, the special needs trust is a first-party trust. Jeff has a checklist that we could send out to you to give you a general idea of what a special needs trust can pay for. Remember, it has a payback. It is quite broad and liberal. A supplemental needs trust, the third-party supplemental needs trust, is the one that is even more liberal. It can be used for anything, basically, for the benefit of the beneficiary. The special needs trust, the first party trust, is called a sole benefit trust. It's more restrictive. The third-party trust can be more broad, but we're happy to send you that checklist. Talking about how much should be funded into a trust, this is a matter of advice. It's a matter of your family situation. It's a matter of whether you're using life insurance as a funding tool. Life insurance is the Swiss Army knife of estate planning in general, but it is a powerful tool for many people in special needs planning. I strongly encourage you to consider life insurance. It is not cheap to buy permanent life insurance. I am not trying to be loose and fast with my advice here about life insurance, but it is a powerful tool for the right family and many times is often overlooked. Using this financial planner, using a retirement plan projection, using the services and the tools of a financial advisor. Some of you will treat your children equally if you have more than one child. Some of you will choose not to, and that's a case-by-case specific situation. And there are pros and cons of this. And so it's a counseling issue as we move forward towards the end here. The first party trust, remember, is to preserve assets for someone who receives assets because of litigation or the military pension, or they've received an inheritance. These slides explain this. This big bolded slide here at the bottom, or this portion of that slide, talks about best practices. So sometimes it's a best practice, many times it's a best practice to have a first party trust already approved. This trust has to be approved by the Attorney General, although it's not difficult to do that, and to simply have that trust approved and ready to go just in case our loved one ever needs it. But again, the focus of the planning is generally the third party trust. So let's move toward the end now. I apologize in advance for this rather squiggly diagram, but what we're trying to really illustrate here is that when we engage in a planning process, we want to have a series of meetings, a series of review sessions, a series of times where you can come and actually take the time to think through all of the choices and the decisions that you have to make. This is more of a narrative summary of our process of estate planning and special needs planning. We talked about guardianship and conservatorship. Again, guardianship is the most invasive form of intervention. Guardianship is needed in many cases. And in Maryland, someone now can have a guardianship and a supported decision maker. And I want to harken back to that horizontal continuum of the power of attorney idea, the supported decision-making idea, and the guardianship idea for you to think about where your loved one falls into that continuum. We have guardianship of the person, guardianship of the property, even though this slide calls it the guardianship of the estate. I did talk about supported decision-making. We do have a webinar on that. We also have an article that I wrote. That article, I think, Jeff, is still #1 on Google, but it's not because I wrote the article itself that I'm touting the article. The article really talks about the mechanics, and it also talks about the substance of the supported decision-making legislation. So I've actually included a lot of the legislation in that article. So we're happy to send that article to you if you would like to read it. I encourage you to wrestle with this concept. I have found that many families with a loved one with disabilities don't really know what to make of this supported decision-making legislation. This very broad legislation that Maryland went from 0, in my opinion, to 100% on this. In other words, they went almost the whole 9 yards, so to speak, on this legislation, opening up the concept that a person with disabilities has many more rights than was ever recognized. And this comes down from the United Nations mandate on human rights. So for many of you, it will not mean anything. It will not change anything that you're doing. For some of you, you will embrace this idea of supported decision making. You'll know exactly what it means to you. But I want to give you permission to be confused by it and to really wrestle with it, because I think some elder law attorneys are still wrestling with it as a utopian idea, while other people will be able to appreciate it. Other people with disabilities will be able to appreciate it, while others will not. So I encourage you to read it, read the article, or read more about supported decision making and wrestle with the idea. So here are some of those bullet points. I won't take any more time today to go into supported decision making. And as we get to the end, again, I want to encourage you to create a memorandum of intent. We are happy to send out a starting point template for you. I'm happy to send out a letter of wishes as well. The memorandum of intent is much more involved. And of course, I encourage you to create your own as well if you would like to. We want you to think in terms of establishing your own estate plan, establishing a special needs plan as part of that estate plan, to have an advisory team and calculate the financial needs, to understand that the supplemental needs trust, so to speak, need to be optimized for retirement plan assets, as we just discussed about the Secure Act. Understand public benefits and read books like the one that I recommended, to generally be envisioning the future and using your imagination to start interviewing or thinking about advocates and really demand answers here, because this is a tough question for many people. And to just generally understand that special needs planning should be part of your general estate planning as you look to getting the proper structure in place for yourself, taking care of yourself first with financial powers of attorney and advance directives. Because remember, the person with disabilities is depending on you. You must take care of yourself first, and by extension, your documents can take care of, in many ways, that loved one with disabilities. So as we set a path forward, we want you to know that we consult with people, whether it's reviewing old trusts or existing trusts or creating new ones. We consult at a no-cost basis on a first meeting. So there is no financial commitment. We want you to complete something called an estate planning questionnaire. We need to know more about you if you're willing to share that. And also, we want you to know that if you do share, there is nothing to concern yourself with as far as sharing personal information, because there is an attorney-client relationship. Even though there's not an attorney-client relationship on this webinar, there is an attorney-client relationship when you consult with us. So we are obligated by the rules of attorney-client privilege and confidentiality. So therefore, there's nothing to fear if you do want to consult. We want you to bring your current documents, whether those are special needs planning documents or other planning documents, so that we can see them. And generally, we don't charge to review documents, and I have very broad knowledge of documents, and I can see very clearly what we are dealing with your existing documents. As I've repeated many times, we want you to have an advisory team, and if you don't have one, we want to help you form one. So just know we are happy to make recommendations and to help you. Again, we encourage you to prepare questions. We want you to bring those questions. Thank you for your questions today. And our most important goal, other than educating you, is really to give you the time to think so that you can make these important decisions and know and feel emotionally confident that you've had the highest and best contemporary knowledge presented to you, so you can know what to do and get recommendations as well. So I thank you, and I'm looking at my time, Jeff. I think we're ending on time with 10 minutes left for questions. And I wish you a wonderful weekend ahead. And for all of you, just know that I know the families that are on this webinar, I know to some degree what you're dealing with just from my experience with clients, with loved ones with disabilities. And I appreciate your time that you spent today to learn and to understand. Jeff, I'm going to turn it back to you.
Thanks, Steve. I appreciate it as always. And thank you to all of you for your questions and for being here today, and for your interest in our webinar series and the firm. So now would be a great time to get any final questions in for Steve. Have him here for the next 10 minutes or so. And we have a couple questions here. I'm going to go ahead and pose to Steve, and I'll have a couple closing thoughts. But go and get those questions in for me, please. First question, Steve, is how quickly can a special needs trust, a third party, be funded by, for example, a second to die insurance policy if both parents pass away unexpectedly and their estate is still in probate?
Thank you for that. I'm going to say that my experience has been that your personal representative or your appointed, your designated fiduciary, and I guess in the case of your second to die life insurance policy, your loved one who's going to make a death claim, that person who receives that death certificate, see, that should be all that's required to make a death claim after your passing, notwithstanding probate. So the key there, just listening to that question, is if you have a second to die policy, you should double and triple check your beneficiary designation. And if your beneficiary designation is properly designated to the supplemental needs trust, then it only should take a death certificate and a matter of a week or two, in my opinion, to properly make that death claim, depending on the circumstances there, and get the funding into that trust. Now, your probate is going on over here, and that should have nothing to do with it, so long as you've double and triple checked the beneficiary designation and you don't pass away on the death of the survivor review with no beneficiary, because that would subject the proceeds of life insurance into your estate. So as long as that is not what happens, which certainly should not happen, and your due diligence, you should be fine in a week or two or three at the most of that death claim being processed and getting that money into the supplemental needs trust. So my assumption there is that the second to die policy is not in a life insurance trust, which sometimes it would be. And my assumption is it's beneficiary designated to the supplemental needs trust or is owned by the supplemental needs trust. And I think in that case, your trustee would make the death claim or your personal representative would make the death claim, but they should not have to make any other disclosure of assets other than the death certificate and possibly the trust itself, the supplemental needs trust.
Great. Thank you for the question and the answer, Steve.
You're welcome.
A few comments about wanting to support a decision-making article. I will include that in my follow-up message to everybody. I have many things to send out to everybody, and it'll be a very comprehensive follow-up message with lots of resources for you. Next question, is there a logical order for planning, like having your financial planning done first and then legal documents, or vice versa?
That's a great question, and that's one of the most commonly asked questions in my experience in the last 10 years. I think that some people think they need to do one before the other. I think that if we were to tell you what really happens behind the scenes, estate planners like me, elder law attorneys, we get a lot of client referrals from our financial advisor colleagues. And the financial, not always, but the financial advisor colleague is working with a client, and perhaps that's your situation, and someone is getting their financial planning in order, and that's wonderful. I think it should be done contemporaneously, like together, but it doesn't have to. You could engage in your planning first and then do your financial, in other words, your estate planning first, do your financial planning second, or you could do your financial planning first and then your estate planning, or you could do it together. Now, the reason that I'm saying all three of those things is that the only thing that matters is, other than you getting the proper planning in place, the only thing that matters to someone like me is that your financial assets are properly aligned. They are properly designated. They are properly retitled as needed to make your estate plan actually work, because we have the estate plan itself and we have documents and so forth. But that estate plan is not going to work right if the financial assets don't flow properly with the estate plan. So we have the estate plan, but then we have the funding or the alignment of assets with the estate plan. So regardless of whether you do it, one before the other or vice versa, or whether you do it contemporaneously, it doesn't matter, so long as in the end of your estate planning phase, we get those financial assets properly aligned.
Okay, thank you. On the financial side, what resources do you recommend for financial advisors to learn more about special needs trusts?
Oh, thank you for that great question. I would say there are a few articles out there that you can glean from the internet without any membership. One of the things I would recommend is something called a website called Elder Law Answers. So a longtime elder law colleague of all elder law attorneys in the country, Harry Margolis, runs a website out of New England called Elder Law Answers. I think you could learn a lot there. There are some articles out there by the Academy of Special Needs Planners you'll probably be able to find. You may be able to find an article by someone like Kevin Urbash or others. I have a few articles out there maybe. And maybe one of the more valuable resources is the Special Needs Alliance. So the Special Needs Alliance is an attorney membership organization, but they do put out some articles that I think have crept out onto the Google landscape, and you can look there as well. And some of those articles are very high level.
Okay, let's see if we have any more questions here. Oh, somebody did email me a question earlier. It's a little specific, Steve, but let me see if you have any general thoughts about it, Steve.
Okay.
We opened a third-party trust and gave to the trust the condominium where our son resides. Can his rep payee account that is funded by SSDI money be deposited into the ABLE account so his ABLE account can pay for condo fees, which include HOA, real estate taxes, and insurance? Any thoughts on that?
Yeah, that's a great question. I would have to, in all honesty, refer to the Maryland ABLE rules about that. I can't recall off the top of my head whether SSDI can be deposited straight into an ABLE account. Now, my inclination is that it probably could, because it's money that's owned by the disabled person. Just to give you an idea of why I don't immediately commit on that, is SSDI cannot be deposited into a first-party trust. So I just want to make sure that we would be giving you the right answer on that, and we can easily find out that answer from Kelly Nelson, who is our contact at Maryland ABLE. But if you don't mind emailing us that question, we could get an answer for you.
Thank you. All right, no other questions. So as I mentioned, I was sending a message with some information that's hopefully helpful to you. This is typically the webinar that has the most information. I'll be including many links, including a link to our ABLE webinar, our trustee selection webinar, the supported decision-making webinar, along with the article about supported decision-making, the information about the book that Steve alluded to, How to Administer the California Special Needs Trust by Kevin Urbash, the letter of intent templates, which I'll send to you, the checklist for what third-party special needs trust can pay for. And I think that's it. As far as our webinar series goes, as we wrap up here, June 7th, next Wednesday at 10, we have Eric Jorgensen from True North Disability Planning, who is a great guy and a great resource. He is all over everything special needs planning. We'll be offering his presentation, A Diagnosis to Adulthood Guide of Navigating the Disability World. And we offer that about once a year or so. It's always a very good resource. And then on June 16th, in person at Busboys and Poets in Columbia from 5 to 7 p.m., we'll be partnering with our good friend, Officer Andre Lingham, who also is the founder of the Center for Elder Justice and Education on World Elder Abuse Awareness Day, Financial Exploitation, Frauds and Scams Targeting Older Adults. And Officer Lingham and Steve will be co-presenting for a special presentation that day. So looking forward to that.
If you don't mind me interrupting, just to say that Officer Lingham is a longtime retired Howard County police officer who was an expert in elder abuse.
Yeah, he is a two-time Howard County Officer of the Year, a great guy. He's presented on our webinar series here before, but it'll be great to present in person with him which is his preferred method, and we always enjoy getting out as well. So I'll check for any final questions. And we don't, so we'll call this one a success. Hope you all have a great weekend. Please let us know how we can be a resource to you. Look forward to seeing you again on the Elville webinar series. And thanks for being here today. Take care.
Thank you, everyone.